Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from Brooklyn, New York. And in today's live YouTube presentation, I will be talking about prosecutorial discretion. Prosecutorial discretion that seems is back. It's a very, very important news because for a very long time, we did not have prosecutorial discretion. I believe in 2017, or almost as soon as the Trump administration came to power, that tool was unavailable anymore to the prosecutors. They could not close the cases, even if they were very sympathetic towards your client or attorney's client, right? Even if they were sympathetic towards the respondent. And now it became known that the head prosecutor sent a memo out to the ICE prosecutors, the memo dated May 27th, outlining the discretion that the prosecutors can exercise. So thank you very much for joining me. I will be talking today about who will be able, which categories of immigrants are likely to have a chance of receiving prosecutorial discretion, what it may mean for them, and how lawyers can use these new guidelines. Well, first of all, the interesting part that the memo says that you don't even have to have now a lawyer's request for the prosecutorial discretion in order to exercise it, which is very, very important. Basically, the prosecutors, if they review the case and they see that the person is likely to fall into one of those guidelines that they may exercise discretion for, may just delay the case or close the case on his or her own. So that's very, very important. But of course, if you have a professional putting the application forward for you, or maybe you're already in removal proceedings and you would like just to highlight certain equities in your favor, that will be very, very important and good. You also will have an opportunity to attach additional documents if a lawyer does it for you, because of course, when the proceedings are just starting, sometimes you will not have such an opportunity. You won't even see the prosecutor, right? And you probably want to get out of the removal proceedings as soon as possible. So who are these people? Which people will be enjoying potentially prosecutorial discretion? Well, first of all, those will be long-term green card holders, especially if they received green card at the young age. Okay? When will this situation play out? Well, the situation that somebody who is a long-term green card holder will be placed in removal proceedings usually will take place if the person committed some sort of deportable offense, small crime. Maybe it was a shoplifting, maybe it was something similar, and the person ended up in removal proceedings. And now the prosecutor will have discretion to close such removal proceedings. Very important. Another group, people who have serious health conditions. Let's say you are deportable, maybe your green card was obtained via fraud, for example, or alleged fraud, and now you have a serious medical condition that is required, and the medical attention is required to be provided in the United States, for example, right? So now the prosecutor will be able to take that factor into consideration and perhaps dismiss your case, which is very important. The age of the respondent, if the respondent is a minor or respondent is an elderly. Very important, guys. There are these kids in removal proceedings. I had a client who was about 5 or 6 years old. When he was sitting on a chair, his feet were not touching the floor. And it was just heartbreaking that someone like that will end up in this mess in this immigration court, especially when you don't have to do that. Kids very often would qualify for special immigrant juvenile status, and they don't have to really, there is no necessity for them to be in immigration court in the first place. So it would be great if the prosecutors would pay attention to such cases and would terminate them so the child can go through a regular filing without even an interview before USCIS. Pregnant ladies will have a chance of having their proceedings delayed or terminated. victims of domestic violence and other serious crimes. You may know that victims of crimes in the United States may receive a U visa. But what are these categories of people? Well, perhaps those are U visa applicants or potential applicants, or perhaps those are people who suffered from a crime, but that crime did not qualify them for a U visa. For example, victims of immigration fraud. I've encountered some cases when people ended up in removal proceedings because some lawyers or people who were not even lawyers filed for some relief for them or immigration benefits that they were not entitled to. And naturally, people would end up in removal proceedings in such situations. So guess what? Now, the prosecutor may be able to close such removal proceedings for them. Also, in the memo, the prosecutors are encouraged to take into consideration physical and mental state of the respondent. If they are primary caregiver to someone, it's very, very important. Here they're talking about the parents of the U.S. children, I believe, U.S. citizen children. So this will be, again, a factor, just like it was during the Obama administration. Also, if a person is a relative of a military member, and if a person is likely to be granted status in the United States, this factor will also be taken into consideration. For example, I know somebody who is in removal proceedings and currently there is no relief available for them. But in 5 to 6 years, their child, who's a U.S. citizen, will be able to sponsor them. So basically, the person will have to go through this removal proceedings, potentially be removed, will be sent back to their home country just to apply for the waiver 5 or 6 years later. It's going to cause great distress to the family and family separation. The person, by the way, is a very successful business person, and employment places are going to suffer that he created for the employees in New York, as well as contracts and business relationships. So it would be great if the prosecutors now, again, had the power to terminate the proceedings or at least administratively close them for the time being for someone like that. Also, they will be taken into consideration if a person was a victim or a witness in a criminal case or represents significant asset to the state or federal government. We're probably talking about business people here. Again, they're encouraged to focus on public safety and national security. Means that if you do have some heavy crime there, you may not be able to meet these guidelines, heavy crime in your history. And the prosecutors will be looking at the ties in the United States, work history, and they will be able to dismiss or, I understand, terminate the case or delay the case. So great news. Don't you agree with me? I think it's a great news. The best part that you don't even have to file for it. It should be automatic, even though I do encourage anybody who believes that they represent equities in their favors, meeting these guidelines, to submit a formal request to the prosecutor closing the case, terminating the case. In many situations, it will allow people to file for adjustment before USCIS, or sometimes just will buy them time until they actually can file for such an adjustment. Now, if you guys have some questions, I'll be happy to answer them. Let me see. Hi, Elizabeth. Hi, Manny. Hi, Bahart. Hi, Rakesh. Any news about the essential workers? Not yet. I actually had a video before that explaining that I believe we're going to have some meaningful news about essential workers and other groups of people that would fall into immigration reform situations later in the year, when they're actually going to be voting on the budget. Hi, Mani. How VAWA works? I'm still at I-130 process. All right, that's a great question. Basically, if somebody is married to a U.S. citizen, but also a child or parent of a U.S. citizen or permanent resident may also qualify for VAWA benefits. But let's say we're talking only about the marriage and someone filed I-130 for you, meaning alien relative petition. It doesn't stop you from filing I-360 or self-petition based on VAWA. It's very important. When you file for I-360, that's a confidential process. Your spouse will not know that you filed for it, okay? And that's why this process was created, is that if you feel unsafe, if you feel abused in your relationship, you may exercise that process without the participation of the spouse who filed I-130 for you. I-130 does not have to be withdrawn for you to file I-360, okay? Hi, Mitesh. Asylum pending and file I-45. I-45 is a general application for adjustment of status. Sometimes it can be filed if you have asylum pending. It depends on whether you can adjust or not.